Hello, everybody. My name is Harvey Brownstone, and today it is my great pleasure and honor to welcome a true legend and icon in the women's movement and the legal profession. She's a trailblazing advocate, activist, author, media personality, and one of my heroes, Linda Silver Dranoff. Welcome, Linda.
Thank you very much, Harvey.
We're here to discuss your book, Fairly Equal, Lawyering the Feminist Revolution, one of my absolute favorite books. You can see it there on the screen. It is, as far as I'm concerned, a must read for not only every woman and every man, every law student, lawyer, and judge, and then some. It's an amazing book, Linda, because you've chronicled in great detail the evolution of women's rights and the struggle for equality in Canada over the past 50 years, and you were front and center in that struggle. Can you tell us, why did you write the book?
Well, I guess I wrote the book because I wanted young people to know what the history was. That history, if it isn't written down, it's as if in 50 years it never happened. And so much of women's history through the ages was not written down, was not considered important by the people who did the writing down of things, that we have a big gap going back historically. I felt that the young people who read it, and I hope they'll read it, will know what happened in the past and what they can try to achieve. I would like many young women to say that you want to make change. This is how you have to do it. And persistence and vigilance are both part of it.
Now, you took us from the world you grew up in, where women had almost no rights. Married women were treated like their husband's property. There was no right to abortion. Women were severely discriminated against in employment. Crimes against women were not taken seriously. There were almost no women holding public office. There was only a handful of women lawyers, doctors, professionals, and you take us on a journey from that world to the world we are living in now, when so much has been achieved thanks to women like you, who really dared to fight injustice and inequality wherever you saw it. You must be very, very proud.
I am. I'm proud, and I'm also grateful that I lived in a society that gave me the opportunity to do it. That as long as I kept pushing, as long as I was persistent, there were opportunities. So I'm very proud of what we accomplished. There is still a whole lot more to do.
It's clear from the book that you were an activist right from the start. And I love the story about you and a bunch of female university students protesting the fact that women were not allowed to attend a debate between President Kennedy, who was a senator at the time, and Stephen Lewis. Can you tell us a bit about that?
I was in first year university, and I was just beginning to understand that there was an organization called Hard House on the University of Toronto campus that was for men only. When it came to this debate, it seemed like it would be a fabulous event. So maybe three of us, me and two others, went to have a chat with the executive director of the facility of Hard House and said, you know, why don't you make this the one debate a year that women can attend? We would really like to attend it. We were so ladylike and gracious and trying to be persuasive. And he just sort of, I just felt like my head was being patted. There, dear, you know, don't get yourself upset over this, but no, we're not doing it. So when the day came, a group of us and others joined us. I think there was 15, 20 people in total that attended. We put up picketed signs, and we picketed right in front of Hard House. And the debate rooms where it was held, the window was open. So those inside could hear us chanting, you know, unfair to women. I don't know if we thought that doing that was going to achieve, you know, all of a sudden we were going to have a valet come out and say, come in, dears, but no, it didn't happen. Anyway, so we picketed, and it didn't change anything in Hard House. It really didn't. What it did was, it showed it gave an opportunity, and it showed that women weren't going to simply take that without an objection, a strong objection, and that's what we did. We strongly objected. A year later, they opened up a debate to women, and the subject was, now is the time. Anyway, I went and found that women were permitted, but you had to sit behind a roped off area. We were segregated from everybody else. Then they had a regular question and answer period after the debate. They allowed questions and answers. So I stood up. I don't remember what my question was, but I was going to participate to the extent permitted. And I was not recognized. The chair would not permit me to speak. You're here on sufferance only, he said. Eventually, 15 years later, Hard House opened to women.
Now, you were a single mom in law school, which I think is amazing in itself. Do you think that your own experience as a single mother made you gravitate towards family law?
I think it made me understand the issues of women's rights because, for instance, there was no childcare facilities at that time, just as one example. Women law students didn't have the same opportunities in articling positions, for another example. But in terms of family law, and of course, being divorced, I understood divorce. But I think what really made me gravitate toward it was that those were the clients, who came in my office. I was in no position to be picky at the beginning, but I got a lot of calls from people who wanted a divorce. And then, of course, the Law Reform Commission of Ontario did a report on family law in 1974, and 1974 is when I was called to the bar. So that became the new thing, and it gave me an opportunity to become involved in an area that was already of interest to me, but it gave me an opportunity to contribute to the development of it. Within the first year I was practicing, they set up, the Ontario government set up sort of a conference with workshops, and the few young women lawyers that were there at that time were asked to be seminar leaders. And that was my first involvement in the family, the Law Reform Commission reports, recommendations.
Did you ever have difficulty representing men as a well-known feminist lawyer?
Not at all. The only thing was, though, that if the man was hiring me only because he wanted to persuade his wife that what his proposal was fair, because otherwise, if I agreed with it, then it must be fair. In other words, he was using the fact that I was a woman to help his case. I didn't much like that. And there were several cases where they were not being reasonable at all. But, when you have a client, you take instructions and they want you to make a particular offer, you make a particular offer. And I knew that what they were trying to do is just use me, but really, he had no intention of being at all reasonable with his wife. Those cases I tried to get rid of. But for the most part, the men who came to me really wanted to be fair-minded. I can think of a couple of cases where I acted for the wife, and the husband went off and married somebody else, of course. And 10 years later, he came to me. He liked how I represented his wife. So in his second divorce, he was going to hire me. And I had several like that. Right?
I'm not surprised. Now, early on in your activism, you discovered that the legal profession, especially male lawyers, were not very progressive or even interested in equality issues. Now, did that surprise you, given that lawyers are supposed to be in the business of protecting people's rights?
Well, I figured out at least, that law is about resolving disputes for some people. And for other people, it's about achieving justice. It did surprise me because I really thought that justice was what it was all about. And there were a number of men who really weren't very sympathetic to women's rights. When we fought for a change in the family laws, there were a number of men who would say to me quietly, I agree with you. I do. This is what would be fair. He said, but I represent a lot of men and I'm going to lose my clientele. So I can't go along with you. So most of them didn't, they were very quiet in the background, even if they agreed with me.
You know, Linda, I got the feeling from your book that you saw yourself as a bit of an outsider in the legal profession. You wrote that even after you had been a highly successful, influential lawyer for 25 years, you never felt included in the old boys club, or what you called the academy of exclusive, high-profile male lawyers. Why do you think that was?
That's a good question. Why do I think that was? Because they were all buddies, I think, or wanted to create that kind of a relationship among themselves. And they wanted to run the family law bar. And they really didn't want interlopers. And in a sense, I was an interloper because I was a woman, but I was also an interloper because I had a different perspective on what the outcome should be of many of these disputes. I mean, I really believe in equality and justice.
I was really struck by your courage as a brand new lawyer to go out on your own and open up your own law practice. That, as you know, that's extremely rare. It's very brave. Why did you decide to do that?
I guess I really didn't think at that time the law firms that ran the legal profession were welcoming to women. My experience trying to find an articling job was instructive. For example, I mean, I had been successful at law school, and some of the biggest firms of the day, they aren't as big as they are today, but they were the large ones for their time. They would call their buddies at the law school, the professors, and say, who should we be interviewing? Who are the up and coming students who we should be interviewing for articling jobs? And mine appeared on 3 of the top firms, and they interviewed me. And I thought, oh boy, look at this. This is going to be terrific. I'm all set. Well, the junior lawyers on the hiring committee interviewed me. 1 or 2 of them said, we like you, don't accept anybody's invitation until we get back to you. I mean, so how much more positive could that be? Anyway,
absolutely.
I waited and waited and waited. And it turned out later, one of the other women in the class had some in at one of the firms and found out what was really going on. And she reported back to me that the senior partners simply did not want to hire a woman law student, period. Didn't matter who she was or what she could offer the firm. So the articling job I got was the best I could find at the time, and I needed some help from one of my professors at law school to get it because I wasn't getting any offers. And I was, you know, I'm a persistent person. I sent out applications. So I articled, and the articling job that I had was not a very positive experience in the total scheme of things. And in the end, I thought to myself, I don't think I have any choice but to open my own office. I mean, I really felt it was that clear that I didn't have any choice, that the idea of continuing, I mean, the handwriting was on the wall. I had this image of climbing a ladder and having a heel come down on my knuckles as I did. So I did it my way.
In reading about your constant activism for law reform, your writing, your speaking engagements, your media work, I'm amazed that you ever found any time or energy to actually make a living. And you were parenting a child. How did you ever find time to represent clients?
Well, I was busy all the time. And I was also, obviously I had to be efficient. And I just always worked. I mean, I was doing something all the time. So after my daughter I put her to sleep, I worked in the evening, right? And we didn't have the computers at that time either, you know.
No. In discussing changes in the law relating to women's rights, you said in your book that the late 70s and the early 80s were the golden age of citizen political engagement in Canada. Why is that? What was so special about that era?
I guess I felt that there were people listening within the government. That was the age of Bill Davis in Ontario, for example. And it was the age of Pierre Trudeau in Ottawa. And they were both, I think, open to new ideas, open to progressive ideas. But that's why that period of time, it was a matter of who was in political power and what the political will was at the time.
One of the points that really jumps out in the book is that you very often pursued legislative reform because of unfair or bad court decisions dealing with matrimonial property rights of women, like the Leatherdale decision that you write about, the 1982 Supreme Court of Canada decision. Just for the benefit of our viewers and listeners, that case ruled that a wife could not share in the husband's property and assets unless she had actually contributed directly to acquiring those assets. So it seems really clear to me that those unfair, inequitable court decisions were really what triggered your activism in law reform.
That's true, because I had hoped that the 1978 Family Law Reform Act, which had different rules for what they described as family property and non-family property, would be useful and would provide for equality and justice for women and men. And Leatherdale was one of the early cases. The legislators were not going to get involved unless I had first, I felt, exhausted all litigation remedies. So I felt it had to go to the Supreme Court of Canada. And
but my point really is that courts did not want to acknowledge a woman's role in a marriage as a homemaker and a childcare provider. And you always advocated for equal sharing of property because marriage is an equal partnership.
Right.
And I think that reading the book, one understands how much you were motivated by court decisions that you felt did not honor those principles. And really, your activism ultimately led to the Family Law Act, which was passed in Ontario in 1986.
That's right.
But a lot of people don't know that you were instrumental in getting the Ontario government to change the law to protect widows who were left out of their husbands' wills.
And that arose because a woman consulted me. And that was a situation. She'd been married 30, 40 years. And she said that her husband had prepared a will leaving everything to his brother. And she'd been a homemaker. And I looked at the law and I realized, I don't remember what year this was, in the early 80s, I guess. And I looked at the law and I thought, how can this be that this woman he can simply disinherit her? So yes, I started a campaign. In other words, it was the actual real life cases that would tip me off. It was the court cases that would tip me off. But you know, you're right, because on the next level, one of the other things I asked for was automatic cost of living increases and support payments to improve support payments based on increases in the cost of living without having to go back to court and pay the money to get the order.
That was really huge. I've got to
it
tell
really
you,
was.
that was really huge, that people's support payments could increase and keep up with inflation and the cost of living without going back to court. That was really, if you had only done that, I think you would still be considered a legend. But of course you did so much more. I have to tell you, I really enjoyed the parts of your book where you talked about some of your most memorable and difficult cases. And one of those was a case by the name of Van Bork that went on for 11 years. And that case really highlighted the sad reality that even though the law provides entitlements the family court system can be manipulated in a high conflict case by a vindictive and highly unreasonable litigant and lawyers. What do you have to say about the family court system? You're retired now, aren't you?
Yes.
So tell us what you really think.
What I've always thought is that it isn't efficient. It takes too long to get anything done. In the old days, I used to think that if one judge seized himself of the case and he was the one or she was the one to hear it all the way through, that it would be a more efficient process. That did evolve eventually into the case conference system, but the case conference system still does not have the same judge hearing the same cases. So every time a lawyer brings a case forward, they have to start from scratch with the judge involved in hearing it. And the court system at this point has become so focused on diverting people to mediation and arbitration that I don't think it's right and fair, because I think if the two lawyers involved think that they're going to settle the case, they don't need anybody to make an order or just insist that they go talk to each other. They'll be able to do it. And even if somebody makes an order, it doesn't mean you're going to get the cooperation from both sides. It's as though they need efficiency experts to come in and lay out a plan that will get to the end result in as quick and as fair a manner as possible.
You also write about a very high conflict custody case that lasted 11 years. Linda acted for the father, who had a horrible time just being a father to his children because of interference from the mother. And Linda, in that chapter, you really illustrate how impossible it is for joint custody to work if the parents simply cannot or will not cooperate with each other.
Yeah, I mean, early on in the days of joint custody, I think that was understood by the courts, and they wouldn't impose it where the parties didn't agree. But I think that changed at some point, that they felt they could impose it. And it was a way also of not making a decision and just leaving it to the parents to work it out. But there were many cases where one parent or the other really has to be sidelined because they really are the ones who are causing damage. Because they're causing damage to the relationship, they're causing damage to the children. So, I guess there were times when I hoped for more definitive decision making by the courts.
Well, I have a saying. I just want to see if you agree with me. I always say that family law cases are not about the facts of the case. They're about the personalities of the parties. Do you agree with that?
Oh, yeah. Oh, yeah. Because even how the facts evolve are because of the personalities of the parties. And some people's personalities are such that that's the reason why the parental relationship isn't working out. That why the mother and father can't get along is because of the emotional makeup of the other party. Boy, somebody should teach people how to pick them a little better than they do.
If everybody did that, there would be no reason for family court, I guess.
I guess.
One of the many reasons I admire you so much, Linda, is that we both believe in public education about the law. You wrote 3 books to help women and men understand their legal rights and obligations, and you had a legal column in Chatelaine magazine for 25 years. That's pretty amazing.
It is, actually, when you think about it.
I was shocked to find out that when you wanted to write a column in 1980 explaining that a wife did not need her husband's consent to get an abortion, the magazine editors told you that this topic was too radical for their readership.
Shows you what it was like then.
It's almost unbelievable. I had to reread that paragraph twice. But eventually you did write the column.
I did.
Now, you've said publicly many times that no woman in a marriage should quit her job to be a stay-at-home mother and homemaker unless she's got a contract guaranteeing her equal property sharing if they split up. You still feel that way?
Oh, yes.
Even though the state of the law does provide for equal sharing, you still think that there should be marriage contracts, cohabitation agreements, prenups?
Well, I guess it depends on people's circumstances. I think that people should, at least young people who are getting together, should at least put their mind to it. What happens if this? What happens if we have children? What happens if you quit working? To make sure that they're on the same page. Depending on what the result of that conversation is, they may need to have a contract, because it may be an eye-opener for one of the other persons who sees that the other party doesn't have the same views that they assumed they would have.
You made it a point throughout your career not to align yourself with any political party. Why?
Well, because I really wanted to be an activist for women's rights, and I felt that if you're partisan, you're dismissed as simply following the party line. And actually, especially if you go into politics, you have to follow the party line. And I didn't have, there wasn't a party that, unless I started my own, that had my line in it.
Did you ever?
And I felt I could be more effective. Pardon me, that's the other thing. I felt I could be more effective because people would, when they listen to somebody who's nonpartisan more closely.
So that's very good advice for a law reform advocate. Don't align yourself with any party because you need to be able to work with whoever is in power.
That's right.
Did you ever consider running for office?
Well, I'm very interested in politics and public policy, and I always have been.
There's a shock.
What?
There's a shock.
Yeah. But going into actual politics, I guess at the time that I thought of it, it seemed too limiting, that I could be more effective continuing to do what I was doing, which was being a public influencer, to use a modern phrase.
Did you ever consider applying to be a judge?
Oh, I thought of that very seriously, very seriously. I must say the first thing that I thought of was nobody will ever want, they will not want to appoint a feminist. In those days, that I simply thought they'll see me as being a women's rights advocate, even though I know I can be very, and am very even-handed, and was in dealing with my clients too.
Well, you also represented many men.
That's right, that's right. Those kinds of things just made me feel you're effective and you're happy where you are. You can accomplish a lot. I always felt that working for equality was a very fine goal to have in life. It was more important to me than making money. I had to make a living, and I did, all that kind of thing, but that wasn't the goal of my life. The goal of my life really has been to seek justice and fairness and equality.
Near the end of your book, you set out the lessons that you've learned as an activist. You give great advice on how to be an effective advocate. And I love the fact that you tell people to trust their instincts. I think you and I both have done that our whole lives. You're a very intuitive person. Are you impressed by the activism that you see today by young lawyers? Is there any?
There isn't as much as I would like to see. I see them concerned, but I don't see as much activism as I would wish. Women's rights would be front and center in any public discussions on matters affecting them if we had a national women's movement. At one time, there was the National Action Committee on the Status of Women, and that was defunded by an ideologically contrary government. But I feel that if women from all diverse areas could get together and speak with one voice, with the help of women lawyers, because women lawyers have the tools to be persuasive, to know what change has to be made. Listen, to even contribute to the preparation of legislation. I still remember that one of the things I did as a member of the Ontario Council on the Status of Women, in 1980, they were doing a new human rights code, and they decided they would put a section in on sexual harassment. Well, I did a line by line, as a lawyer, analysis of their draft bill, and I reworded the sexual harassment section because I didn't feel that it did the job. And I still remember with great pride that was accepted. I don't remember what else was, but I remember that one was accepted. But women lawyers have so much to offer to achieve change if they work together. That's one of the reasons I was the founding chair of the Ontario Bar Association's Feminist Legal Analysis Section, which is still operating today. It's almost 30 years later.
So what do you think is the next frontier in law reform? Are there battles still to be fought to achieve real equality?
Well, I think that not just laws, but funding to enforce the laws are necessary. For instance, we have pay equity laws that could work. They could be improved. There's a thing called pay transparency that has been a suggestion by the Equal Pay Coalition. Childcare has not been properly, but that's a funding issue. We don't have enough childcare. That's a funding issue. Violence against women, we've made all kinds of changes to legislation, but there are still unconscious and conscious biases that are not making it work as effectively as it might. But yes, for instance, there are other changes. I did an article for the Star last year on this question of online abuse and harassment that is affecting women in politics and affecting a lot of people in prominent positions, that there seems to be no control over the kind of trolling, defamation that's occurring online. And I did a piece that talked about, first of all, making the platforms subject to the same rules of defamatory libel as newspapers, so that they have to control what's going on their platforms. I talked about changing the laws of defamation to include online harassment. I talked about changing the criminal code stalking and criminal harassment rules to include online stalking and criminal harassment.
What we call cyberbullying.
Yes, but the point is there are solutions. And that's, I guess, why I think if there was an organization there to push the kinds of ideas that would help make for positive change. Listen, there's rules about equality within corporate structures, but women are not making it up the corporate ladder. So there's a lot of things that still have to be done, and it's not just the laws, but the laws have to be implemented. They have to be applied.
Now, in writing about the tremendous progress that's been made towards equality and fairness, you said in the book that you worry about how easily it can all be taken away. What gives you that fear?
In 2006, Paul Martin's Liberals had made a deal with every province in Canada and put aside the funding for a national, accessible, affordable, universal childcare plan. An election was called. Harper came in with a minority government and he simply canceled the whole thing.
So you're really saying that any law or benefit can be taken away depending on the will of the government.
That's right.
So in your book, you really say to people not to take for granted what we have. We must always be vigilant. We must always be alert and alive to the possibility that rights can be taken away.
That's right. We cannot assume. And I guess I go one step further. I don't remember if I put it in the book or not, but in my own views, is that the way in which to prevent that is to have a system of government that requires consensus thinking, consensus decision making.
So Linda, I would be remiss if I did not take this opportunity to ask you, what advice do you have for judges?
Wow. Be of good courage. That would be my, know that you're in a position of great authority and great respect, and be of good courage, and don't back away from making the important rulings that arise out of the facts in front of you. Many, many judges do that, and I applaud them for it.
In 1989, you married Jack Marmer, a forensic accountant,
Right.
and you write in your book, he was successful in his own right, and his ego didn't require him to disparage me to elevate himself. I thought that was so well put. And I have found in my own life experience, for many high achieving women, it's been a real challenge to find a supportive partner who is not threatened by their success. Do you agree that that's a big issue for women?
Oh, indeed. It absolutely is. And it isn't something you always know right offhand. And there are women who, try and make themselves be less so that he will feel more. But you see, Jack and I, we got to know each other in a professional manner for some years. So I got to know him, and he got to know me as a human being. I don't know that I would have taken the risk otherwise. I mean, how can you really know what somebody's like? But for a high achieving woman, you have to have a partner who appreciates and respects you, and doesn't in any way try to denigrate what it is you've achieved. And so many women know so many men who fit that bill, unfortunately.
Now, I have to say to our audience, Ms. Silver Dranoff is much too humble and modest to mention this today. But Linda, you've been acknowledged many times for your incredibly important contribution to the legal profession and to the women's movement. Linda received a Governor General's Award in 2001. Linda was appointed to the Order of Canada in 2012. Linda received the coveted Law Society Medal in 2006, among many other accolades. Linda, it has been such a thrill to have this opportunity to sit down with you and reminisce about your monumentally important career. Thank you so much for taking the time to speak with me.
You're quite welcome. It's been a real pleasure. It's been a real pleasure, because you're such a warm and enthusiastic interviewer and friend. Thank you.
My guest has been Linda Silver Dranoff, author of Fairly Equal, Lawyering the Feminist Revolution. My name is Harvey Brownstone. Thanks to our producer, Steve Silver, no relation to Linda. Thank you for joining us. See you next time.